Now for what's tipping the scales of justice in the Idaho student murders case for defendant Bryan Kohberger. He's going to be back in court today for day 2 of his all-important motions hearing. His defense lawyers are asking the judge to throw out most of the evidence in the case because they say it all hinges on an unconstitutional genetic investigation process. Kohberger's lawyers also argue that the search warrants were tainted by police misconduct.
When Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Courtroom laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pool in Pennsylvania, and there was no warrant for that trash pool either.
All right, in this segment, I want to focus on that trash pool. And these are the beautiful victims who were killed in November of 2022. And so the defense team here is trying to get out. The biggest thing is the DNA that came from the knife sheath, the trace DNA that was left on the snap, comparing it to a trash pool and DNA obtained at the Kohberger home, and they found what was on the knife came from the spawn of Papa Kohberger. And so the defense team is saying this is unconstitutional, the genetic genealogy testing that the state done, unconstitutional. Okay. Let's talk about that, because if it's excluded, does the case fall apart? Let me bring in our brilliant legal eagles, David Bruno and Joe Tamburino, to talk about this. Okay, so the unconstitutionality, so they say, of what was done here. David Bruno, what do you think about that?
We're back in the Fourth Amendment. Reasonable. Right? What is reasonable? What is not? And when we're talking about this garbage, when we're talking about databases, we always have to talk about the expectation of privacy. And that is really relevant here. You know, traditionally and historically speaking, when you put garbage out at the curb, you do not have an expectation of privacy when you discard that particular property. On the issue of these databases, the question's going to be, well, what was in the databases? How did they get those profiles? And did the people know that they were giving up sort of their rights? When people submit DNA and they're trying to get those lineages and those histories and things, there are a lot of provisions and you're waiving a lot of rights. And it really is fact sensitive on what databases they went into, because what we're talking about is the DNA on the knife sheath. And that essentially is the smoking gun. If they get that in and they can prove that Kohberger's DNA is on the knife sheath found under one of the bodies at the crime scene, that's game over. So the question becomes, I mean, that DNA sample that's there in the crime scene, there's no expectation of privacy to that. They're doing the DNA on that. And then it's the comparisons is really what is at play for the Fourth Amendment. The reasonable, was it reasonable? And also expectation of privacy. I think the government's on pretty firm foot on both those questions.
David Bruno, I think you should get some CLE credits for all the teaching you're doing this morning on this show. Thank you for that. Speaking of the expectation of privacy, Joe Tamburino, I know you've got a lot to say about this. Apparently, the court thought Mr. Kohberger deserved some privacy. Yesterday, the judge had closed off part of the hearing from the public. Our courties were very disappointed, and then allowed the public to see the other half of the hearing, making everybody wonder, well, why was it we couldn't see all of it? Curious what you think about that ruling.
What I think is it's a wrong ruling, and media organizations should sue, because you can't just close a courtroom. I mean, federal law, state law, but mostly federal law under the First Amendment, we have open courtrooms. Yes, in certain juvenile cases and things like that, but 99% of the time, you just can't shut the courtroom doors. And the judge did it under this theory of, well, we're going to be talking about evidence that if it gets out there, it could taint the jury, a future jury. Well, if that's the reasoning, then you would basically close every criminal hearing before trial, because of course you're going to hear evidence that might not be admissible at trial, and some potential juror could hear it. That's why you go through jury selection. You try to weed out those people. So closing the courtroom is ridiculous. Additionally, it violates Idaho's victim laws. A victim has rights. A victim families have rights in Idaho, as with all states. And 19.5306 under Idaho law says that victims can be in all court proceedings. Actually, in Idaho, they say they could be even in juvenile proceedings. So we have a violation of open courtrooms under the First Amendment. We have a violation of a victim's rights. And I think, I mean, if that happened here in Minneapolis, media organizations here are very active, especially since the Chauvin trial years ago. There would be a lawsuit to get those courtroom doors open.
Boom. Drop the mic. Joe Tamburino, you deserve CLE credits too for all of that legal presentation. Thank you. Yes, and I'm sure our courties at home are applauding that too, because we want to see it. We want to see what's going on with this guy. So we'll leave it here for now, but he's back in court today. We've got another Kohberger hearing today, so that'll be later on Court TV Live. Joe is coming along with us for some Court TV Live. We got to say goodbye and a big thank you to our friend David Bruno for everything this morning. Have a great weekend, David. We'll see you soon.